Okay, so thank you very much for coming. Welcome to the Waterfront Winter IT Seminar. My name's Carole Hailey. I'm the founding partner of Waterfront. And I thought it might be useful just to run through the agenda. I'm going to be talking about offering a cloud-based service. I'm going to hand over to my colleague, Jean-Marc Pettigrew, who will be talking about open source software. Mike Clark will be doing a roundup of recent IT case law. And then my partner, Alison, is going to be having a Q&A session with one of our clients, Mohammed Malik, who's the CEO of Acovia. In terms of time frames, we've allowed 10 to 15 minutes per topic. We don't want to bore you. And we thought it would be more useful to have questions at the end of each topic rather than waiting to the end. So if you have any questions, you'll be able to ask them at the end of each session. So I'm talking about offering a cloud-based service. I'm the head of the Technology and Commercial Law Department at Waterfront. And I read this week that, please come in. I read this week that cloud adoption is growing at a rate of between 5 and 11 times faster than traditional software. So I thought it might be interesting, certainly for me, yes, have a quick show of hands. Who here currently offers a cloud-based service to their customers? Okay. Brave people. Who currently uses a cloud-based service at work? Okay, that's quite heartening given what I'm going to say. As you know, we're lawyers, we're not technologists, and I'm well aware that many people in this room know much more than we do about the cloud, so I thought it'd be useful to explain what we mean, or I will be meaning, by a cloud-based service. And forgive me, technologists, if you don't entirely agree, but what I mean, for the purposes of this talk, is putting software on a server in a data center and distributing it using the internet rather than providing a copy of your software to your clients to install on their own servers. I realize that's extremely high level, but that's what I mean by offering a cloud-based service. Obviously, as most people will be aware, data centers or cloud providers typically offer, but not always, but offer a pay-as-you-go pricing model, computing resources on demand, allowing easy ramp up and ramp down. And I'm focusing on the use of the cloud to offer your clients a cloud-based service, not using the cloud for your business. And there's obviously a big gulf at the moment. We're more of us are customers than suppliers, judging by the show of hands. It's not popular in some quarters to say this, but legally, cloud-based service, from a legal perspective, is a natural evolution of the old, what used to be called, and I'm showing my age here, the old bureau-based service, which moved to hosted service, software as a service, and now it's a cloud service. And I realise again that that's a bit sacrilegious in some quarters, but legally, that's the evolution that's gone through. So, benefits of the cloud. You can see there what Gartner said earlier this year. And it's absolutely the case that speed of deployment, lower costs, and easier customization generally means more fleet of foot contracts. And that's obvious by a consideration of the issues that are inherent in the traditional sale of software licenses, which historically involve complex end-user license agreements, support and maintenance agreements, protracted debates over pricing against perpetual licenses, against term licenses, trying to lock customers into automatic renewals of support and maintenance because they want to walk away after a year. Certainly our experience, software licenses historically are purchased from capital expenditure budget, which means a more senior person within the customer organisation has to sign off the contract, which means a closer scrutiny of the contract. Customer internal IT departments have to mobilise costly infrastructure to host the software. And obviously, a lot of you know better than I that there are issues and costs around supporting multiple versions of the software across your client base. All of which is reflected in the legal and contractual complexities. So the contractual benefits of offering a cloud service are clear. It's typically done as a single service agreement, not a license agreement. I think it's important to note that usually, but again not always, there's no actual license of the software to the customer if you're offering a cloud-based service. You provide a service, you don't provide a license. Revenue for the use of the software and support is combined into a periodic payment, so there's no customer option to stop support and maintenance. And obviously, software upgrades can be are rolled out across all instances, leading to economies of scale, so I understand. But certainly the net result of that often is simpler contracts, easier to negotiate, quicker to get signed. So far, so good. But understanding the risks, what's the problem with the cloud from a legal perspective? You can see on the slide there the Bloomberg study in August estimates that the cost to customers of downtime of 13 cloud providers since 2007 is $71.7 million. Now, I think that's grossly underestimated, and I couldn't find how they had calculated that cost, but I think you could add a naught at least. Earlier this year, I was asked to speak at a meeting of the Amazon Cloud Services European sales team. And for the benefit that anyone that doesn't know, the Amazon cloud was certainly is reputed to have been the first cloud, and certainly has the largest market share. So anyway, I was asked to talk to the European sales team about the challenges faced by our clients who were considering using the cloud to provide a service. And in a nutshell, this is a problem. If you're a company using the cloud to provide a service to your customers, then unless you've got a data center of your own, you will have to outsource a critical part of your service to a third party, which means that you're stuck in the middle of a contractual chain. You've got your customers at one end, you've got your service provider at the other end, and you're stuck in the middle. If you're offering a B2C service, if most of your customers are consumers, then from a legal perspective, in our experience, the issues are less actually about legal risks being stuck in the middle, but more about downtime and the loss of revenue that happens. But if your customers are other businesses and potentially much larger organisations than your own, then your customers will want assurances and commitments in their contracts with you. But will you be able to get the same from the cloud service provider? And therein lies the nub of the key risk. Looking at it in a little more detail, I thought it would be useful just to have a very quick look through the key things that your customers might expect from their contracts with you, and therefore what, conversely, you might wish to include in your contracts with a cloud provider. On the left-hand column is the key things, and there's another slide as well, of what your customers will expect from you, in most cases, in their contracts with you. The right-hand column is a rough approximation of how this translates into the contract with the cloud provider. So just going through them from the top, technical description. Obviously, you want to know what you're getting, and to be certain it can't change without you knowing about it. Acceptance testing may or may not be relevant, but if it is relevant, then you want to be able to acceptance test before you go live. IPR warranties and indemnities, favourite legal chestnut, that one. If you are putting your software into a cloud provided by a third-party cloud provider, and they are also providing the platform on which your software sits, then you want to know that you've got the rights to use the platform. Pricing, self-evident, transparent. You want transparent pricing, you want a clear process for any amendments to the prices. Service levels, again, you want robust service levels, and if they're not met, you want it to be clear what's going to happen. Security and backup kind of speaks for itself, but generally robust security, backup and disaster recovery obligations. Liability, if it all goes wrong, what are you going to get in recompense? Data protection and confidentiality speaks for itself, and I'll talk about data protection again in a few minutes, but speaks for itself. And termination and exit management, two sides of the same coin really. You want to know that if your contract with a cloud provider comes to an end for any reason at all, that you've got sufficient time to migrate to your next supplier, your replacement supplier, and also that the current cloud provider has to facilitate that. So by comparison, I put here two extracts from the Amazon Enterprise Cloud Services Agreement. Now, I've used Amazon, but it's important to stress that the risks are the same across certainly all the major players that we usually come across, most particularly Rackspace and Microsoft Azure. So it's not particular to Amazon. I've just chosen to use it because it's the contract that I know best in this field. So looking at the service description definition, it means the description of, forgive me for reading, but the description of features, functions, pricing, limitations, restrictions associated with the service. So far, so good. That's what you'd expect a service description to say. But then it goes on to say, as such descriptions may be updated by Amazon Web Services from time to time. And that's it. That's where it ends. So you're completely at the mercy of Amazon changing their mind at any time about any element of the service description. So if your pricing to your customer is predicated on Amazon continuing to offer their service at a particular price, Amazon can change their minds and quadruple it overnight. And there's nothing you can do about it. Now, historically, Amazon's prices have gone down, not up. But obviously, as lawyers, we like to deal in certainties, and there is no certainty in this contract from Amazon. There is nothing to guarantee that what you get today from them is what you're going to get tomorrow, which begs the question of how you can make any commitment to your customers that what you provide today, you'll be able to provide tomorrow, or be able to provide tomorrow for the same price. And looking at 8.4.1, it speaks for itself. Amazon Web Services will not be liable for any service interruptions. So no matter what the service description is, if they don't provide a service, then they're not liable. The whole agreement is rife with issues, but even just these two alone basically make it not worth the paper it's written on. And anecdotally, I advised the first UK government department to use Amazon Web, or to officially use Amazon Web Services about 3 years ago, and I was responsible for negotiating the contract with Amazon. And even with the carrot dangled under their nose of having a UK government department using their service, they would not bend on most of their contractual terms. And in the end, our client elected not to use them for the customer-facing, or rather consumer-facing, public-facing part of its service. It only used it for development and testing because it couldn't take the risk. So what this means is all of the commitments that your customers expect from you cannot be passed through to your cloud provider, or at least not under the Amazon terms, and typically not under Rackspace, not under Microsoft Azure, and not under many others, which means that the liability for breach of your customer contract stops with you, even when it's not your fault. You can't back it off to your customers. I just wanted to touch really briefly on data protection. Cloud service providers are data processors. So as the data processor, you are liable for what they do. So it is crucial that cloud providers comply with the rules
that you have to comply with. The two most common principles that come up in conversations are 7th and 8th, personal information must be kept secure, and personal information must not be transferred outside the European Economic Area. There's obvious caveats to that, safe harbour principles being one of them, but some of the larger cloud providers will not even commit to the location of their data centres being in the EU, which is, it's a problem from the outset, because you don't know where the data is being held. So, in conclusion, by their own admission, the market leading by, certainly by share of revenue share of cloud service providers consider that they're providing a commodity. So it's a low price, it's high volume, it's scalable product with non-negotiable one-sided contracts. It's a commodity. It's like buying a book from Amazon, buying some cloud space. So when considering using the cloud to provide a service to your customers, it's worth asking yourself if you'd describe your service as a commodity. If not, then beware of your choice of cloud provider. I ran through this with my colleagues this morning, and they said that my part of this evening was unremittingly negative. And I don't want to leave you that impression, because there are a number of alternatives, both in the way that legal relationships can be constructed with a cloud provider and the type of cloud offerings. So the key message that I think that I would like you to take away is to be discerning. Remember, if you're using a cloud provider to provide a cloud service to your customers, then you are outsourcing part of your service, and don't just follow the crowd to the cheapest cloud service provider. And that's it. Has anybody got any questions? Oh, thank you very much.